Thank you for your invitation. Distinguished guests, ambassadors, Mr. Deputy Minister. I see colleagues from the Parliament as well. After such a brilliant presentation by the Deputy Foreign Minister, not much is left for us as lawyers to speak about. But on the positive side of this, I feel more relaxed now. And I want the audience to be relaxed too. And as Farid mentioned, I am a lawyer, but I never practiced law. I had an academic background. I used to teach at the Baku State University. I would like to start with an anecdote, with your permission. Lawyers have a lot of cynical anecdotes about their own profession, and I would like to share with you one of my favorite. Imagine a person who drives a car in a city which he doesn't quite know well, and then he gets lost. And he sees a pedestrian and decides to ask for a direction. And he asks, "Excuse me, could you please tell me where I am now?" And the pedestrian tells him that you are in the car. And then the guy says that you must be a lawyer. He said, "Yes, how did you know?" And he said, "Because your answer is correct, but absolutely useless." It is indeed, there is a long-standing and endless disputes between politicians and lawyers about what is possible and what is not, what is allowed, what is not allowed, what is necessary, what is not necessary. So it's endless, and it's everywhere, in every country. So here the situation is this, like where the first panel is dedicated to the legal aspects of it. And we have the situation when, as our Deputy Foreign Minister already mentioned, when Armenian constitution in its preamble has a reference to the Declaration of Independence, which itself contains a clear territorial claim towards the sovereign territory of Azerbaijan, because it refers to a joint resolution of then the Supreme Soviet of Armenian Socialist Republic and the Regional Soviet, as the council was then called, of the former Nagorno-Karabakh Oblast. It's about reunification. And since Armenians always say that they never officially recognized Karabakh as part of Armenian territory, which is, I have a trouble to agree with. In fact, officially and indirectly, they made moves to make it clear that they do recognize Karabakh as a part of Armenian territory. You know, there is a document called International Covenant on Civil and Political Rights, and every member state is supposed to provide a periodic report to the International Human Rights Committee. And in the 90s and early 2000s, Armenia always wrote in its report with regard to Article 1 of the Covenant, which stipulates the right of all peoples to self-determination, that Armenia protects the right of the people of Nagorno-Karabakh to self-determination. And the International Human Rights Committee always replied in its general comments to Armenian government that Armenia is supposed to provide reports only with regard to its internationally recognized territory. So international community never recognized Karabakh as part of Armenia. Armenian politicians also seemingly never recognized it, but in certain international procedures, they did attempt to do so. So that shows clearly what their intent was about. Now today, when Azerbaijani government, and it's not just the government, you should understand perhaps that this is a general expectation of our society, because I do not represent the government. In fact, I am in opposition to this government. But there has always been a general expectation of this country. All political forces agreed on the certain modalities of resolution of the conflict. It is unfortunate that we had to have recourse to use of military force, but that's only because the peace talks or peaceful settlement of the dispute was never possible. But now peace is somewhere on horizon, but horizon is a very tricky concept. You always go towards it, but you never reach it. Now, Armenian constitution, this reference which the preamble contains to the Declaration of Independence, is very troublesome. You know that there is a constitutional opinion. The Constitutional Court of Armenia now provided an opinion on that preamble, which is, in fact, itself very difficult to understand. If you read the Constitution of Armenia, it clearly says which articles and chapters cannot be amended at all, which articles and chapters can be amended only by referendum, and the rest can be amended by the parliament. Now, preamble is not mentioned anywhere among those provisions. So logically, we faced three options. Preamble can be amended, cannot be amended. Preamble can be amended only by referendum, or preamble can be amended by the parliament. Unfortunately, the Constitutional Court of Armenia opted for the first possible solution and decided that preamble cannot be amended at all. And by doing so, the Constitutional Court of Armenia made the situation even more difficult, because previously the demand of Azerbaijani government was focused only on the preamble, and not entirely on the preamble, but on that particular phrase which referred to the declaration. So we're okay with the rest of the preamble. What we expected from Armenia and demanded from them is just the deletion of that particular phrase. But after the decision of the Constitutional Court, which stipulates now that preamble cannot be amended, now the demand of Azerbaijani government consequentially is all about now constitutional redesign of Armenian society, which we never envisioned, because Armenia put itself in a very difficult situation now. They cannot amend the preamble within the framework of the present constitution, but to get rid of that preamble, they will have to adopt entirely new constitution. Well, I hope if they ever decide to do so, they don't do it in the French way, because if you know, France, when they adopted their constitution in 1958, they decided that the preamble of the constitution of 1946 should remain in force. Again, we have no interest in constitutional design of the Armenian society, but the Constitutional Court of Armenia now put the entire country of Armenia in a very troubling situation. And to be honest, because I don't represent the government, I'm not a participant of the negotiations, I don't know what's on the table. right now and how the government is now negotiating this particular aspect of this problem. But I can assume, as a lawyer, that if a constitutional change will remain a valid claim from the Azerbaijani government, then there is only one solution: is to change the entire constitution of Armenia. Unless, which is another perhaps positive aspect of a negative situation, Constitutional Court of Armenia decides to change its own decision. This is, by the way, one of the reasons why we do not trust Armenia when they say that now we have constitutional judgment and the Constitutional Court decided that this agreement on the Joint Commission on delimitation of borders does not contradict the Armenian constitution. And we say, no, this is not a guarantee for peace, because any future composition of the Constitutional Court may decide to revise this decision. And then we're stuck again. There's one hypothetical solution as well. Let's imagine that the Armenian side offers such a solution. What if, they might say, they abolish, they null and void the declaration itself? There is a formula, the maxim, which in Latin goes like, cesante ratione legis ceset et ipsa lex. In English, it means when a reason for which a law was adopted ceases to exist, then the law itself becomes ineffective. So, in other words, if a declaration of independence, if Armenia decides, because it was adopted by the parliament, if the parliament of Armenia decides to null and void the declaration itself, then the preamble to that declaration becomes empty words. But I'm inclined to disagree with that hypothetical solution as well. Because Declaration of Independence is a single historical act full of wishful thinkings, but those wishful thinkings may lead to anywhere. By the way, distinguished Deputy Minister of Foreign Affairs mentioned Armenian claims, reciprocal claims, or what they believe to be reciprocal claims towards Azerbaijan, when they say that Azerbaijan also should change its constitution because the Azerbaijan constitution preamble contains a reference to the Constitutional Act on State Sovereignty, which states that the Republic of Azerbaijan, the Azerbaijan Republic, is a successor state of the First Republic, which existed in 1918, 1920. Now, as a lawyer, I have to say that that particular phrase in the Constitutional Act of Independent State Sovereignty, adopted in 1991, October 18, has never meant to have a legal effect or consequence. Because according to the international law of state succession, there are several concepts which we have to take into account. One is a date of succession. Date of succession is a date upon which a successor state replaces a predecessor state. Now, that date is quite often not immediate, because it's understood that it can take some time for a state to prove its statehood and to get recognized. So a couple of years may pass, maybe longer, I don't know. But it should be a reasonably short period of time. Now, in our case, the Republic, which ceased to exist in 1920, and the Republic which reappeared in 1991, we have a 71 years time gap. This time gap is neither reasonable nor short. So you cannot speak about date of succession in this particular case. There is another concept which is very important to take into account, and that's the concept of newly independent state. It is a spatial criteria. Newly independent state in international law, in the Convention on State Succession, means a successor state which territory immediately before the succession belonged to a predecessor state. Now here we have, again, the criteria of immediate. And here's why, for example, when Azerbaijan Republic reestablished itself in 1991, the territory which it had legally was a territory which immediately before the independence belonged to the Azerbaijan Soviet Socialist Republic. And here's why Almaty Declaration becomes relevant and the uti possidetis principle becomes effective, as distinguished Deputy Minister rightly mentioned in his presentation. But then again, Armenian side claimed that Karabakh never was a part of Azerbaijan, and when Almaty Declaration was adopted, Karabakh already declared its own independence and then joined with Armenia, and so in effect it was not part of Azerbaijan, which is legally a nonsense. Am I running out of time? Okay. Which is legally a nonsense. So with regard to the modality of conclusion of peace treaty itself, according to Armenian constitution, it should be, Armenian constitution says that upon the recommendation of the government, the parliament decides on establishing peace. That's declaring war and establishing peace. The formula that is used in Azerbaijani constitution is slightly different, more archaic, I would say. Upon the request from the president, as the parliament authorizes the president to declare a war and conclude peace. It's a very archaic formula, which never used nowadays. Since the end of World War II, there have been several hundreds of conflicts, interstate conflicts and internal conflicts. And according to the UN statistics, around 15 or something % of those conflicts ended with peace treaty. And that is why states no longer declare war. Historically, this precedent first happened at the end of the World War I, when all the parties to that war, when they concluded peace treaty in Versailles, America also signed that treaty, but the Senate, Woodrow Wilson, a Democratic president, signed it, but the Senate was controlled by Republicans, and the Senate refused to ratify the peace treaty signed by the president. And then America found itself in a very strange, and I would even say an absurd situation, because all the parties to the World War I concluded peace among each other, and the only remaining country at war was America. And the question was with whom America was at war. So then the president decided to declare peace. And that's the competence that American Constitution does not provide. And it was disputed, and the Federal Supreme Court of the United States had to consider a commercial case, by the way. A company sued the government because during the World War I, companies were under certain restrictions with regard to international trade. And then when the war was over, one of the companies sued the government by saying, if the war is over, then the restrictions should be lifted. If the war is still ongoing, then whom we are at war with. And then having had to decide that particular case, the Supreme Court of the United States had to approve the newly acquired competence of the American president to unilaterally declare peace. The reason why I mention this is because when Armenians signed, we hear sometimes that, okay, Pashinyan is in a very difficult situation, opposition is pressing, there's a foreign pressure as well. What if he fails to get a treaty ratified in the Armenian constitution? This could be one of the solutions, because officially, neither Armenia nor Azerbaijan never declared war towards each other. But this is all academic presentations and more or less hypothetical solutions. What is really needed to decide upon is that how do we do with the current situation after the decision of the Constitutional Court of Armenia, because it made situation even harder, because now the parliament cannot amend the preamble, and it cannot be amended by the referendum as well. And now it seems like when Azerbaijan, the government, demands from Armenia to amend a constitution, it seems like Azerbaijani government demands from Armenia to change its constitution entirely, which has never been our intention. So I'll probably stop here. I hope there will be questions. Thank you very much.
Yeah.